Who are we ready on first, Deputy McLeish?
I'm sorry, Your Honor, I didn't answer you. Mr. Schmidt is ready. We're getting his clients. One is here, one is on the way.
Okay. Who do we want to go on first? Is this Mr. Powell or Mr. Crutcher?
This is Mr. Crutcher, CR 21-284.
Is that for docket call? Go ahead.
It is, Judge. We received an offer from the state. We intend to reject that at this time. Ask that the matter be set to judge.
All right, court will set Mr. Crutcher for jury selection beginning beginning January 31st. So, Mr. Crutcher, if you make bail, then you are to report to the Van Zandt County Courthouse to the basement. And if you are in custody, then we'll just bring a notice of notice of appearance over to you. And so your case is going to go on the court's jury selection docket, and it will remain there until your case is called for trial. Okay?
Yes, sir, Your Honor.
All right. So, well, your case will not go on January 31st, needless to say. But after that, your case will move up, and then hopefully it'll get called soon.
All right. Thank you, sir.
You're welcome, sir. All right, this is cause number CR 21-235, State versus Gerald Wayne Powell, set for pretrial. Mr. Schmidt.
That's correct, Judge. At this point, we're going to ask for an additional pretrial. I did file a pretrial motion, but we're going to hold on that until after some of these preliminary matters are addressed. I do believe last week Ms. Curry about the mental health evaluations that she's setting up, that they were getting some additional information. I'm not 100% sure where they're at on that, but I hope that it's imminent. So at this point, we're asking for pretrial to be passed to the next docket.
Okay, I just now noticed that I thought the state was there. They just weren't saying anything, but I don't. Mr. Woodwike, are you there? You're muted. Camera's off. Let's see. Ms. Heisel.
Sasha's downstairs.
Ms. Heisel's downstairs.
Yes.
Judge, Ms. Heisel told me she would be downstairs today and that Mr. Woodwike would be joining us on YouTube.
Okay, thank you.
Or Zoom.
All right, so you're asking to carry pretrial forward then?
That's correct, Judge. And eventually we're likely to need to contest a pretrial hearing, but until those evaluations are completed, we'll ask for additional stuff. So I know that it has not been done at this point.
All right. Are you available on March 8th?
Yes, sir.
All right, we'll set Mr. Powell then for another pretrial hearing on March 8th. And we'll check in on the status of the other evaluations.
Yes, sir. Thank you.
Judge, I apologize. I had my computer muted and didn't realize that we had started.
That's okay.
I was looking at a blank screen. It looked as though the jail folks were talking to each other, but I didn't realize we were starting and I couldn't hear anything. So
That's okay. We were just talking about you.
I have no doubt. That's all right.
I think Miss Abney's probably watching, but just in case you need the notes on Mr. Schmidt's clients, Christopher Crutcher, page 11. He rejected state's offer. We set that for jury selection beginning January 31st. And then Mr. Powell, Mr. Schmidt said that he had filed some pretrial motions, wanted to hold off on asking for a hearing on those until some of the other preliminary evaluations were completed. And he just asked that we carry pretrial forward until the evaluations are completed. So I reset pretrial to March 8th to give a time for the evaluations to be done, and then we'll take up pretrial.
Thank you, Your Honor.
I believe that's all of Mr. Schmidt's.
It is,
Deputy-
Judge.
Thanks, sir. Deputy McLeish, do we have anyone else that's ready?
Yes, sir. Mr. Stevens is ready.
Cheryl Miller, CR 1864.
Be sure to speak up so that the judge can hear, okay?
This is a hearing on Ms. Miller's motion to revoke. Do we have an announcement, Mr. Stevens?
Yes, Your Honor, I was just appointed to represent Ms. Miller on the 13th of January. At the time I was appointed, I didn't even have a copy of the motion to revoke, so we obviously would be asking for another court setting.
We'll set Ms. Miller then on the contested docket on February 24th.
All right, so that'll be 1:30, I'm assuming.
Yes, sir, 1:30, unless Ms. Miller is on bail. If she's on bail, then it will be at 9 a.m.
Yes, sir. Yeah.
Is there anything further on Ms. Miller?
No, Your Honor, not on Ms. Miller.
Okay. Lana Calder, CR 21322.
She's not up here quite yet, Judge.
Okay.
Let's see. And I think I have Mr. Patterson also said, I was just appointed a couple of days ago, and he got COVID.
Is that Donald Patterson?
Yes, sir.
You said he is positive for COVID?
Yes, sir.
Okay. And are you asking for additional time on pretrial since recently?
Yes, sir. Yes, sir, I am.
All right. Are you available on February 22nd? Well, we got February 10th or February 22nd. If one's better than the other.
The 10th, or what was the other, 10th, 22nd, or was there another date?
No, it was just those two.
Okay. Well, Judge. I guess we could do it on the 22nd, Your Honor. I've got Kaufman County Court at Law number 1 that I've had set for several weeks now at 1:30.
Okay.
I could be here, but it might be like 3 o'clock before I got here.
I think that's fine.
Okay, cool.
That's fine. And if by chance you get stuck over there, if you could zoom in.
Yes, sir.
For pretrial, wouldn't be anything too cumbersome. So, all right, we'll set pretrial then February 22nd at 1:30.
All right, thank you, Judge. And that's all I have for now until Ms. Calder comes up.
Okay, thanks, sir.
Stevens.
Deputy McLeish, on Mr. Adams' client, Stephen Foster, he's not going to be here today. So we're going to just need to reset him for February 10th. And then the same thing will be true of Casey Chester's. I think I've already granted a continuance on that for Chelsea Caver, but we'll just need to get a note or notice to her that her attorney is sick, and we're going to reset it for a week after next.
What will be that date for?
Same February 10th.
Okay, very good.
And then no need to bring them up unless there's some issue I need to be aware of.
They're actually right here in the room right now, but I think they heard you and I'm gonna give them reset forms as well.
Okay, good.
Mr. Stevens. And Mr. Stevens's other client is now in the room.
Okay. Mr. Stevens, are you ready on Ms. Calder?
I am ready, Your Honor. Yes, sir.
Ms. Calder, if you'll come on up, please. This is cause number CR 21322. On the charge of manufacture or delivery of a controlled substance in penalty group 1, 4 to 200. And also on writ WR 2187, possession of controlled substance less than 1 gram. We'll go ahead and take up the indicted case first. Any announcements on pretrial?
Judge, I'm going to ask for another pretrial setting. I've spoken with the prosecutor about a week ago, and when the new case hit the office, we didn't have an offer of punishment then. And so I'm waiting for an offer of punishment, and I don't actually have the discovery either, Your Honor, on the indicted case.
Is it the digital or online discovery, or is it like discs?
No, it's digital. As far as I've checked the website a couple of times, it's not on there.
Mr. Woodwhite?
Judge, I'm looking at now, the button has not been pushed. I'm pushing the button right now on the indicted case. Ms. Calder also has an unindicted case, which will be going to the next session of our grand jury, which we believe will be before the 90 days. But just that's our announcement for right now.
Okay. How
And
much
so
time?
So Mr. Stevens will have discovery before the end of this hearing, but obviously he doesn't have it now. So state would be unopposed to reset of the pretrial for the indicted case.
Do you know when when Ms. Calder's case will be presented to the grand jury, like what date?
Grand jury is scheduled for this Friday, so in 3 days.
Okay. I was just trying to see if I need to set it in on that February 22nd date or in March. Mr. Stevens, do you have a request either way?
I would prefer March, Your Honor, but if you need to put it in February, I could probably make that work.
All right, we can set pretrial then on March 8th. Ms. Calder on the indicted case, and then if she is indicted on the other charge, then we could set that for arraignment on that same day.
Oh.
All right, and so do you want to go ahead and take up your writ at this time?
Yes, thank you, Your Honor. And I would be calling my client only for the purposes of this bill reduction hearing.
Ms. Calder, if you'll raise your right hand, I'm going to place you under oath. Ms. Calder, do you swear that the testimony you give to the court in this matter now on trial before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, make sure you speak up loudly and clearly so that I can hear you and so that my court reporter can take down everything you say, okay?
Yes, sir.
All right, go ahead, Mr. Stevens.
Thank you, Your Honor. Please state your name for the record.
Lana Michelle Calder.
Lana, how long have you been in jail?
It's been November the 4th.
November the 4th, you've been continuously held in jail here.
Yes,
Is that
sir.
correct? Okay. You've got two different cases. They're both manufactured delivery cases. They both had $25,000 bonds. Is that correct?
Yes, sir.
You obviously would not be able to make the $25,000 bonds, or you wouldn't be here.
Yes, sir.
Do you have any cash that you could put toward the bonds?
Not that much about the bonds, but I do have a little cash.
Okay. And you told me when I visited you in jail that you didn't really have any property that you could sell or pawn or mortgage. Did you to put toward the bonds?
I don't have anything.
Okay. And you told me that you are disabled, correct?
Yes, sir.
Okay, and you get a Social Security check of like $792.
Yes, sir.
If the bonds got reduced, who would help post the bonds?
I will be posting them.
Okay, along with help from your family?
Yes, sir.
And where would you live if the judge reduces the bonds to an amount that you could get out?
Back to my residence
Which is where?
in Villanueva, Texas.
Okay, and you told me you have transportation to get to and from the courthouse, is that correct?
Yes, sir.
Okay, now you are disabled, so are you able to work also, or
No.
not able to work because of your disability?
Yes, sir.
And what are your just so the judge knows what your
I owe
disability
just
is.
heart failure, COPD.
Okay. And are you asking the judge to reduce each one of these bonds from 25,000 down to $10,000?
Yes, sir.
If he were to do that, do you think that would be an amount of bond that you and your family would be able to scrape the money up to post?
We could try.
Okay. And can you assure the judge that you won't make any court appearances or any other obligations the court may put on you, like going to the probation department or something like that?
Yes, sir.
Okay. Are you asking the judge to reduce the bonds?
Yes, sir.
Are you promising this judge you'll reappear in court when ordered to do so?
Yes, sir.
Pass the witness, Your Honor.
State.
Ms. Calder, you were arrested, I believe you said November 4th, is that correct?
Yes, sir.
And you were arrested on a warrant, is that correct?
Yes, sir.
And at the time of your arrest, you were arrested again for a new charge, is that correct?
Yes, sir.
And you understand that both of those are first and second degree felonies, correct?
Yes, sir.
Judge, I have no further questions.
Mr. Stevens, closing.
Nothing further, Your Honor. Back rest.
All right, you want closing?
Yeah, I'm closed, Judge. Just, we're going to ask the court to reduce the bond. She is disabled. She has some pretty severe medical problems. She has a place to go live. She has transportation to get to and from the courthouse. And we're respectfully asking the court to reduce them, Your Honor.
Sure would like.
Judge, we would ask that the court not reduce the bonds. 25,000 is more than reasonable for two. I believe both will likely be first degree felonies. Once indicted by the grand jury this week, or not indicted by the grand jury, that case should resolve itself. It has not yet been 90 days. There's no reason for seeking release because of delay. We'd ask that the bonds be left as they are.
All right, based on the testimony provided to the court's going to find that the bail in the amount of $25,000 for these charges is not excessive or oppressive. So the court's going to find that 25,000 is appropriate, and that should remain the bail in each one of these cases. So the court's going to deny the relief requested under the writ.
That's my business for the day. I'll be excused, Your Honor.
Yes, thank you, Mr. Stevens. We'll see you back on at least March 8th, if not sooner. Yes, ma'am, I'm ready.
Yes, sir. The only other attorney that we have physically present is Jeff Wood, and he's speaking with one of his clients. But I do have the three inmates up here whose attorneys are Zooming. I have Mr. Pedro Nino, Michael Marley, and Kendrick Willis.
All right, I believe I have all of their attorneys in Zoom. Let me see here who's who. I have, let's see, Richard McConaughey. I have Kurt Knoll. I have Mr. Ashmore. Bolton. I'm gonna, let's bring Pedro Nino up.
Mr. Nino, come on up, sir.
Mr. McConaughey, can you see and hear me okay?
I can now.
Okay, excellent. And can you see your client, Pedro Nino?
Let me see, Your Honor. I'm scrolling through. I can, Your Honor.
All right. And if you want to, you can right click on him and pin him in your viewing area there. It may help you see.
Yes, sir.
All right. This is cause number CR 21301, State versus Pedro Nino, and we're set for docket call. Do we have any announcement, Mr. McConaughey?
Your Honor, I've been in discussion with the state. I believe we've reached a plea agreement and need to set this for a plea date.
Okay. And is there any kind of time constraint on anything that he has to come up with, or anything that's time sensitive on the plea, or just next available?
Next, Your Honor.
Let's see, I've got available.
Well, the only time restriction would be for me to get back out there, Your Honor. So I do have a couple of trials in Tarrant County that are taking place. So in the next 2 to 3 weeks.
What about February 10th?
That would be fine, Your Honor.
February 10th. Okay. All right. We'll set Mr. Nino then for plea on February 10th, and that will be at 1:30.
Yes, sir. Is that going to be live or on Zoom?
That will be on Zoom. So you or Mr. Bolton will be at the Van Zandt County Jail, and then you'll meet with your client back there, execute the paperwork, and then I'll conduct it via Zoom.
Yes, sir. We'll be there.
All right. Thank you, sir. Good to see you. We'll see you back on February 10th.
Yes, sir. See you then.
All right. Let's bring in Michael Marley.
Your Honor.
Hello, Mr. Marley. We're going to give Mr. Knoll a chance to get set up here. Just brought him in, so give him just a moment while his technology is connected.
Yes, Your Honor.
Good afternoon, Mr. Knoll. Can you see and hear me okay?
I can, Judge. I'm not sure. Can you see me and my screens?
Yes, sir.
Okay.
Yes, sir. We can see you and hear you just fine.
Okay.
All right. This is cause number CR 21225, State versus Michael Paul Marley on docket call.
Judge, court may or may not recall it, that I had received some information about a hospitalization that occurred shortly before the events that causes Mr. Marley to be here today after I finally figured out the hospital in Athens, which I believe is UT Health East Texas, Athens. I filed a motion on January 4th to receive for an order to obtain those records. I believe an order would have been sent. I haven't seen a signed order yet. Doesn't mean one isn't, or may have slipped by somehow, but I'm just waiting on an order to be signed by the court. If the court did get an order, and I think it did.
And remind me, I do recall reviewing that. I'm gonna have to refresh my recollection though. You were asking for the court to order the hospital to provide you records for Mr. Marley cost free. Is that correct?
That's correct, Judge. Now, to be honest, they usually send a bill anyway, but yes, that was my request.
Do you know if the court has the jurisdiction and authority to order a third party to provide records cost free?
I do not. I guess what I would say is, since this is it is an indigent case, I don't have case law to tell the court that it has the authority to order that. And as I indicated, usually they send me a bill regardless. If the court wants to strike that, I'm happy to proceed, do whatever I need to do to get the records. They're not going to be that lengthy. I would think maybe a couple of days worth of records. There was a surgical procedure and medications that were given in prescriptions. And I just needed to get that in hopes of working out eventually a plea on this case. My recollection is the first written offer I got on this case, which is enhanced, was 45 years. I think the lowest offer we've received was 40. if I recall right, and I'm just trying to do the best I can in whittling that number down. I think there may be some mitigating issues in this record.
So I'm not confident that I have the jurisdiction to order the hospital to produce anything in this case. So, however, since Mr. Marley is indigent, if you as counsel incur a cost, Mr. Knoll, then you can forward that to the court, and the court will count that as a reimbursement on Mr. Marley's behalf for his defense, much as I would an investigator or something of that nature. So I'm not comfortable ordering a hospital to produce something that I don't think I have jurisdiction over.
Okay, Judge, then some of the hospitals use their own HIPAA release form. In other words, it's just a standard one. Sometimes they will use it, sometimes they won't. I will contact the hospital, find out if there's a specific one that they use. We'll get Mr. Marley to sign that and go through that process, I guess, is probably the easiest way at this point. Considering the couple of years worth of COVID stuff that we've been going through, I know it seems to take longer to do everything these days. I would hope to have it in a month, but the truth is, I think probably 60 days is more realistic. If nothing else, just the number of individuals that work in hospitals that also seem to be sick and not in their position. So I would ask for a 60-day reset.
I'll meet you halfway. I will set it for March 8th, and we'll just do a status on the medical records.
Okay.
Hopes that they get it done in the next 30 days. So quicker you get the release to Mr. Marley, the quicker they can then process it.
Judge, I'll make that call today, and then if they can email me something, I'll get over to the jail and have Mr. Marley execute that.
Okay, so we'll reset. Do you have any scheduling conflicts for March 8th?
Judge, let's reset it. If push comes to shove, I may wind up having to do a Zoom again, but let's leave it at that. Mr. Marley's been incarcerated quite a while now, so let's do March 8th, assuming a 1:30.
Okay. All right, so we'll do that on March 8th, and like I said, any cost that's incurred, just forward that, and we'll reimburse that to you as indigent counsel.
Okay, thank you, Judge.
You're welcome, sir.
May I be excused?
Yes, sir.
Thank you.
Thank you, Mr. Marley.
Your Honor, may I say something, please?
Well, if it's about your case or a question about the law or something of that nature, then it's best that you talk to Mr. Knoll first. If it's about Mr. Knoll, then I want you to put it in writing.
Okay, yes, sir. Yes, Your Honor.
All right, so I'm assuming that it's about Mr. Knoll.
It pertaining to my medical records, there might be a chance because when I came into jail, they had to, the medical people here had to look at me, look at my stitches. And so they've got records of it through Southern Hospital, and they maybe can save a buck like that.
Okay.
If there's any consolation to it at all, and I apologize completely for if there's any consolation at all, I apologize.
No, okay. So what I'll do is I'll inquire as to if the jail staff has any medical records, Mr. Knoll, and if they do, then I'll ask Ms. Taberham to make sure that you get a copy of those sent to you. For whatever they have. I'm sure you're still going to want the hospital records, but whatever they have, maybe that's you can get something going quicker.
Yeah, I knew there was some, but I didn't figure it was going to be everything I'd prefer to have. Let's put it that way.
All right, thank you, Mr. Marley. I'll look into that.
Yes, Your Honor. Thank you. Y'all have a good day. Thank you, Mr. Knoll.
Thank you, Judge.
You're welcome.
Marley.
Correct, yes. And if you'll bring charges back.
Who do we have now, Ms. Deputy McQuish?
This is Mr. Kendrick Willis.
Okay. Good afternoon, Mr. Willis. How are you, sir?
Afternoon, sir.
All right, let me get your lawyer in here. All right, Mr. Ashmore, can you see and hear me okay?
Yes, Judge.
All right, we have before the court, Mr. Kendrick Willis, CR 19-211, on pretrial for driving while intoxicated third or more.
Judge, our announcement today, Mr. Willis, I thought you were on this morning's docket, so I apologize for not meeting with you and being there personally. The state prosecutor's office and I have conferred about Mr. Willis's matter. We don't believe there are going to be any contested pretrial motions, and we have none to urge at this time. We do ask for a reset because we are working with Mr. Woodwike and the Van Zandt County District Attorney's Office on a probation offer, and we just do not have that finalized yet. And again, I'll accept responsibility for that. Mr. Willis wasn't in court this morning, so I hit timeout on that and didn't press that forward. I'll immediately pick that ball up and start running with it again at the conclusion of this hearing today. So we just asked to come back on a reset, Your Honor, and I think we'll have our business resolved before the court.
All right, when do you want to come back? You have to remind me about your scheduling. We can, next available would be February 10th, then the 22nd. And is this plea going to be for probation?
That I believe it is. And, I mean, I'm always asking for that dismissal and an apology, although Tyler has never been kind enough to, I'm just kidding. February 10th, I'm looking right now, Your Honor. But I do believe that the state and I had a meeting of the minds today about a probation offer for Mr. Willis. And the 8th, excuse me, Judge, the 10th is open now that special setting has been moved from February to March. So the 10th works.
All right, then I will set Mr. Willis then for a docket call and or plea on February 10th. I will note that my docket reflects that he's seriously delinquent on his attorney fees and some bond supervision. So I would ask that those be, if it's going to be a probation plea, that those be accounted for in the probation conditions.
Yes, Judge.
So if there's nothing further, then we'll be adjourned in this hearing, and Mr. Willis will see you back on February 10th.
All right, sir.
Thank you, Mr. Ashmore. I appreciate you zooming back in.
Yes, Judge. I think we have one other, Lauren. Let me get Fleming.
Yes, and she's here in the courtroom. This is cause number CR 21-261, State versus Laura Joy Fleming, and we're set for docket call today.
Judge, we have presented, sorry, if that feedback's my responsibility. Judge, we've presented evidence that we have regarding some confusion over the right to take property or obtain property. We've given that to the state. The state has investigated that, and their position remains unchanged. And I believe that leaves us with nothing else to do except request a jury trial in this matter based on what Ms. Fleming and I have discussed in the past. And I'm not there this afternoon to visit with her further, but she's at this juncture rejected all plea offers. And again, we've negotiated in good faith with the state. Their position in good faith has not changed. And I think that's where that leaves us, is to request a jury trial setting, Your Honor.
And what is the plea offer that she's rejected?
I'm looking for it in my notes, but my recollection off the top of my head was it's a TDC offer. And
Judge, this is not my case. This is Ms. Heisel's case. The last offer I have notes about is 14 months state jail and a fine.
that sound right?
I'm
That-
unaware if it ever got lower than that. That's the last documented offer in the case. Maybe it was, something else was conveyed to Mr. Ashmore, but I don't have records of that.
That I think there were some discussions informally about a position lower than that, but that does sound about right. And I have the advantage of having my laptop and I'm going through any notes from hearings that I've made.
Okay, just one second.
Yes, Judge. Thank you.
All right, so the court will, Ms. Fleming, you understand that if you reject the plea offer and you ask for a trial, the court's going to give you a trial. If you decide the Friday before you go to trial that you want to take this offer, I'm going to tell you no, because you've had your opportunity. You understand that? Okay, so I'm going to set you for jury selection beginning January 31st. So that'll be next week. You'll report down to the basement of the courthouse at 8:30. You will not go to trial that week, but you're going to need to show up each month until your case is reached for trial. So there will be a staff member of mine down there and they will reset you for the next day. Okay. So that's going to begin next week on the 31st. So, but now I need to address, why were you not here at 9 a.m. this morning?
I thought the 25th was tomorrow. I've been really sick. I have a ear infection. I've been night for like the last 3 days. I'm so sorry. I mean, I'm definitely.
Like, you need medical attention?
Probably.
Probably. Like, do we need to call you an ambulance?
No, I don't need an ambulance. I'm just saying I probably should go to the doctor.
I mean, if I thought I was going to die, I probably have already gone to the doctor. So, Mr. Ashmore, I'm going to drug test your client today. And so I'm going to keep her here at the courthouse until she goes. And if she tests positive, I'll just tell you, if she tests or admits that she's violated conditions of pretrial release, I'm going to find her bail to be insufficient, so that you're aware. Okay?
Yes, Judge. I understand.
All right. So, Ms. Fleming, just have a seat. Stay in the courtroom until you're ready to use the restroom. If you need a glass of water or something, you're welcome to bring that in here. Is that all you have, Mr. Ashmore?
Yes, Judge. That's all. Thank you so much.
All right. I appreciate you reappearing today.
Thank you, Judge. Have a great afternoon.
You as well. All right, Deputy McLeish. Mr. Wood, ready?
Yes, Your Honor, with Mr. Lopano.
Good afternoon, Judge.
Good afternoon, Mr. Wood. How are you, sir?
I'm good. How are you doing?
Excellent. Let's see, let me get over here to Mr. Lopano. John Anthony Lopano, CR 2396. I believe we're set for docket call today.
Judge, in fact, we've, Ms. Hazel and I have worked this case out. Your Honor, we're ready to proceed on a plea. On this case, we've executed the paperwork. We have it here currently. So we're ready to plead this case this afternoon, Judge.
Okay, if you'll just take that judgment and read the terms to me, because I don't have access to it.
Judge, the offense in which we're pleading to is actually paragraph B of the indictment, which is an injury to a child with criminal negligence. The statute for that offense is 2204G. It is a state jail felony. The terms of the plea bargain are to plead guilty to the injury to a child with criminal negligence. The punishment is to be assessed at 19 months in a state jail facility, a fine of $3,000. In addition to that, Your Honor, there are two misdemeanor cases that Mr. Lopano has: a theft of property and a false report to a police officer. In those two cases, the first one, the theft of property, is DA control number 2021-1419. The second DA control number of the false report to a police officer is 2021-14 1420. And both of those cases, Your Honor, are set to be taken into consideration under 1245.
Are there any reimbursements?
There's no reimbursements, Your Honor, no restitution.
No restitution. And what about court costs? 290?
Court cost is $290. I'm sorry, Your Honor, there is a reimbursement fee of $105. And then court costs are $290.
And what about credit time towards the 19 months?
And credit time is 379 days, Your Honor.
Okay. Mr. Lopano, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down. Make sure you speak up loudly and clearly for me so I can hear you and so my court reporter can make a record, okay?
Yes, sir.
Your name is John Anthony Lopano, is that right?
Yes, sir.
Mr. Lopano, are you a United States citizen?
Yes, sir.
Do you read, write, speak English?
Yes.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jeff Wood. Are you pleased with his representation of you?
Yes.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over with Mr. Wood and that you have signed that you do not understand?
No, sir.
And where you signed in the paperwork, you're telling me that that is your true and correct signature and that you only signed it once you were satisfied that you understood what you were signing?
Yes, sir.
Mr. Wood, do you believe Mr. Lopano would be competent today?
I do, Your Honor.
And you've explained to him his rights?
I have.
Do you believe he understands those?
I do.
Mr. Lopano, you are charged by indictment with a state jail felony offense of injury to a child. And you've heard the plea agreement that Mr. Wood has recited to the court that you would be pleading guilty to a state jail felony injury to a child with criminal negligence. That state jail felony carries a range of punishment of confinement in a state jail facility for not less than 6 months or more than 2 years. That means any sentence handed down by this court or a jury would have to fit within that range. And also you could have a fine imposed upon you, but it could not be more than $10,000. Do you understand that?
Yes, sir.
And you heard Mr. Wood read the plea agreement. Is that right?
Yes. Yes,
And
sir.
is that your understanding of the plea agreement and what you're asking the court to approve today?
Yes, sir.
All right. So at this time, Mr. Lopano, I'm going to ask you, how do you plead to injury to a child with criminal negligence, a state jail felony?
Guilty.
Are you pleading guilty to that crime because it's true that you committed that crime?
Yes.
Has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty to that crime?
No.
Court will accept the defendant's plea of guilt. Mr. Wood, any objection to the state's evidence?
No objection, Your Honor.
All right, state's evidence is admitted and the court does take judicial notice of Mr. Lopano's judicial confession. Anything further from the state?
Judge, the state would relate to the court that there is, we are in compliance with victim notification. We have not received a victim impact statement from the child who is an infant or the child's mother. But we are in compliance. We have notified them. We just have not received any notification back.
All right, thank you, Mr. Woodwhite. And Mr. Woodwhite, could you go ahead and summarize the evidence?
Judge, I'm going to read Ms. Heisel's notes. It is her case. Sheriff's office gets a call from CPS. They're at the Children's Hospital in Dallas, from Children's Hospital in Dallas, with a child that has a fractured skull. The doctor at Children's Hospital says the injuries are consistent with inflicted blunt force trauma or shaken baby syndrome. The sheriff's office begins investigating. Mother of the child says that she left the baby with her boyfriend, who is the defendant. They've met a few months earlier and he had recently moved in. Defendant sends text messages during the day that the baby is throwing up but is now sleeping. Mother gets home, the baby is still throwing up, has a bruise on the temple. Mother takes the baby to train Mother Francis here in Canton. They take her, the baby, then to ETMC in Athens. And the baby is then care flighted to Dallas. The defendant sends some text messages which are inculpatory. The defendant then is interviewed. He says that he was sitting on the floor. He was sitting playing video games with the baby on the bed, and it's possible that the baby fell off the bed. He admits to sending the text messages. We believe that the defendant caused, through criminal negligence, a fractured skull to the victim.
Thank you, Mr. Wood. Mr. Wood, any objection to that summation?
Not as far as the office.
Okay. All right, then based on the evidence, the court will find that there is sufficient evidence to convict Mr. Lopano of this offense. Court will follow the plea agreement as recommended by the state. Court hereby convicts John Anthony Lopano of injury to a child with criminal negligence, a state jail felony. Court assesses his punishment at 19 months confinement in the state jail facility. Court will award him credit towards his sentence of 379 days for the time that he has spent in jail on this cause. Court orders him to pay a $3,000 fine, $290 court cost, reimbursement of $105. The court will dismiss and take into consideration under Section 1245 DA 2021-1419 and DA 2021-1420. Mr. Lopano, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to your right with Deputy McLeish to be fingerprinted. Good luck to you.
Yes, sir. Thank you.
Thank you, Your Honor.
Thank you, Mr. Wood. Are you ready on Mr. Bruner at all?
Well, Judge, so Mr. Bruner, we did not bring him in, and I was going to explain to the court why. I got the evaluation report on Mr. Bruner earlier today and had an opportunity to read it. Obviously, it came back Mr. Bruner's competent. So I'm apparently not a very intelligent individual or cannot communicate with Mr. Bruner, one or the other. I don't know. Nevertheless, I've not had an opportunity to really, again, sit down and talk to Mr. Bruner. I wanted to get the valuation report before I did that, and I got it again today. So I think in just the efficiency of time, Your Honor, I'm asking for maybe a date in March or February, so that at that point in time, I'll go and see Mr. Bruner and see how his response is to me regarding hopefully maybe trying to work this case out accordingly. And if that can happen, hopefully then on that February date, I'll have an answer with the court, or I'll have an answer for the court of whether or not that can happen or whether or not we just need to set this for trial.
Are you available on February 22nd?
I'll be available.
Okay, then let's just go ahead and we'll set Mr. Bruner then for docket call on February 22nd at 1:30.
And I will, like I said, meet with Mr. Bruner, and if he is in a relatively good state of mind and we can work something out, Judge, I'll get with the court before that time to see if we can't expedite that if possible.
We do have a few settings that are available before that. So if that happens, you let me know, and the sooner the better.
Okay, that's no problem.
Thank you.
And then Mr. Turnage, Your Honor, we didn't bring him up either. Obviously, all right, John. Take care, sir.
Yeah, no, let me go ahead and call that case. It's CR 2198-199, State versus Brett Lawrence Turnage, status on his waiting list for the mental health hospital. Go ahead, Mr. Wood. I didn't mean to interrupt.
Judge, I've got an email from the court coordinator. She's informed me that I think his status, and Mr. Woodwhite might know as well, but I think it's moved up to, I think, number 196. I don't have the paperwork in front of me, but I believe it's number 196, if that's right. So
I think it's 191, but
191. Well, okay.
We could put the word approximately in front of that. I think we'll cover.
Well, maybe that gets him in there about 2 or 3 days ahead of when I thought he was going to maybe go down. So
lucky.
I guess we're moving up the chain on that, Judge, and I don't really know what else to do on that case at this point.
I think it's just a waiting game at this point. So, all right, well, let's set Mr. Turnage out then. Do you have your calendar with you?
I do.
Let's look in April. What about April 12th April 12th or 14th.
I don't have anything important to say, Your Honor, so that'll work.
Let's do April 12th. We'll just do a status and see where he's at on that date.
Okay.
But are you having an opportunity to visit with him at all, just to keep a gauge on?
I talk to him on the phone occasionally when he calls, every other day he calls about something, and I talk to him intermittently through that way, and so.
Okay, well, if anything that's concerning to you, you'll let me know.
Sure.
You have anything else today?
So I believe that's it. I believe that's it.
All right, man. Good to see you.
Good to see you. See you, Tyler.
Thank you, Jeff.
Okay.
Thank you, Dakota. You're welcome.
See update on this Villanueva. Deputy McLeish, I believe that that concludes our jail docket today, unless you're aware of something that I'm not.
Judge, what happened to, I'm sorry, Judge, what happened with Donald Patterson? That's on my docket, but my docket may be old. It may have already been reset or moved or something.
Oh, yes. I think that was the earlier one. You weren't with us. Mr. Stevens reported that the defendant had tested positive for COVID. So we just reset him for pretrial to February 22nd.
Thank you, Judge.
Your Honor, is there anything else we can do for you over here at the jail?
No, ma'am, I believe that is good there, but I need Mr. Woodwide to stick around.
I will remain on the Zoom, Your Honor.
Thank you, sir. Ms. Villanueva, you'll come forward. All right, we're on the record, CR 21271. This case was called in the morning, State of Texas versus Teresa and Villanueva. And Ms. Villanueva is represented by Mr. Mitch Adams. And the court announced this morning that Mr. Adams was ill and unable to be at court. And the court has reset Ms. Villanueva for docket call on February 10th. I had a note that Ms. Villanueva did not report in November and December to the pretrial release department. And so the court requested a urinalysis exam today.
Excuse me, what do you mean not report?
I can't hear a word you're saying.
What, not report?
I just had a note that you didn't report in November and December.
I've done everything I'm supposed to do.
Okay, well, it doesn't matter. I mean, really, just a note that I had. And so I asked for your analysis, and it's been submitted to me that you have admitted that you smoked methamphetamine on January 23rd, 2 days ago. Is that right? All right, Ms. Villanueva, that's a violation of your conditions of pretrial release. That's a violation of your conditions of bond, in other words. So, Ms. Villanueva, I'm going to find that due to your violation, that your $50,000 bond is insufficient, or it's going to order you into custody and find that your bail is insufficient and increase it to $75,000. So I'm going to have you step forward here with Deputy Phillips. He's going to take you into custody. Mr. Woodwide, the only other one we're waiting on is Ms. Fleming. Waiting for Ms. Fleming to do her test. So, that's already been set for jury selection. So you don't have to stick around, but I was just going to let you know that you've already heard me announce, Mr. Ashner, that if she refuses or admits or tests positive, then I'm going to find her bond insufficient as well.
Yes, Judge, if you need us, just let us know and we will relog in or come on over if anything else arises.
Yes, sir. Appreciate it.
Thank you, Judge.
See you soon. All right, we'll be adjourned. All right, this is cause number CR 21261, State of Texas versus Laura Joy Fleming. Ms. Fleming, I've already addressed your case with you and your attorney, and I've reset your case. This is with regards to the request to administer your analysis test as a condition of your pretrial release. I see here that you have admitted to smoking methamphetamines on or about January 19th of 2022. Ms. Fleming, that is a direct violation of your conditions of pretrial release. You previously had bail in this case in the amount of $100,000. Due to your violation, the court is going to find that you have violated your conditions of pretrial release. The court's going to find your bail to be insufficient. The court's going to order you into custody.
Can I please get one more chance? Like by the 10th, I will be clean, I promise.
You can post a new bail of $150,000.
$150,000, please.
Well, you had Ms. Fleming, you had $100,000.
Please, I didn't, please.
Ms. Fleming,
I'm so sick right now.
hey, your decisions have consequences, and I can't
My
help you.
chance.
I've given you a chance. Given you a chance. I gave you conditions of pretrial release, and I told you that if you did not comply with those, what the action was going to be. So, deputy, go ahead and take her into custody at this time.